No, Your Honor.
All right, Matt, we can
All right.
go live.
The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to the March 9th session of the Massachusetts Appeals Court. My name is Mary Sullivan, and your panel today will consist of me, Justice Desmond, and Justice Singh. This oral argument will follow all the usual rules of oral argument. Each side has 15 minutes. There is no rebuttal, and counsel are encouraged to get to the heart of your respective arguments. You can assume that we are familiar with your briefs. For counsel and also for those of you who may be watching, if we have technical issues, we'll do our best to resolve them. If for any reason we have to go offline, we may come off the live feed, but we'll go directly back on as soon as matters are fixed. We'll all keep our fingers crossed that that'll be unnecessary. And finally, if for any reason you see any of us looking to one side or another on our screen, it's not an intention. We mean no disrespect. We're actually just looking over at our other screens that have our cases, our notes, the parties' briefs, and the records. So with that, we will call the first case of the day, 19P0695, Commonwealth versus Denito, is it, counsel?
Yes, Your Honor.
Okay, thank you. Attorney Sheketoff, I believe you're up first.
Okay, good morning, members of the panel. The way I view this case, the law is pretty straightforward. I have to show that a tactical decision by trial counsel was manifestly unreasonable. The factual record is pretty contained also, because we have the trial court's findings of fact, where he appeared to credit fully the defense lawyer that testified. I point out that the defendant's affidavit was also introduced as an exhibit, so that is part of the record. So the Commonwealth's case consisted of three basic foundations. The victim's testimony, where she claimed that she had been raped. The defendant's recorded statement to the police, where defense counsel testified at the hearing that he thought that was helpful to the defendant because the statement says, in effect, that I engaged in consensual sex with the alleged victim. And thirdly, the testimony of the defendant's, and I put this in air quotes, friend, who testified that they had had instant messenger exchange on Facebook months after she had been interviewed by the police, during which he told a different story about what had occurred, saying that he had mistaken the victim for his wife, and that when she said stop, he did stop.
Could you just clarify the timing of that? She claimed to have the conversation months after speaking to the detective, or did she claim to have the conversation soon afterwards, but didn't disclose it until months after?
I'm not, you have me on that one, Your Honor. I'm not 100% positive of the record on that point. All I can say for certain is that the exchange that allegedly occurred between the defendant and this woman, Melissa, occurred after she had been interviewed by the police. So that was her story. That's her reason why she didn't tell the police about it when she was initially interviewed by them, because she hadn't had that conversation yet. It's shortly before trial that she discloses to the prosecution, who discloses to the defense, that this conversation allegedly occurred. It no longer physically exists because she had deleted it from her, she had deleted her entire Facebook page.
Is it also true, Attorney Sheketoff, that she and the defendant had a cordial outing or had met for drinks or something shortly before the trial or sometime in that time frame?
Yes. So on the record, it appears that they were friends. In fact, the prosecutor argued that to the jury, that they were friends. And they did have a friendly relationship. But my client would not be the first individual who was surprised about what people actually thought of him.
Do we have anything in the record to suggest that she didn't think highly of him other than her account of the IM message?
So this is how I view it, Your Honor, and I think that's a very fair question. The defendant in his affidavit, and the trial lawyer doesn't dispute this in his testimony, told the defense lawyer that this conversation never happened.
Mm-hmm.
So if the conversation never happened, it seems to me to be a fair inference that if she made up such a conversation, she had serious hostility towards him, which she was not showing publicly until she testified. The background testified to by defense counsel from his client was that they had lived together, they had had a sexual relationship, and that he left her to be with his wife, to marry his wife, and bought a house. And the defendant was convinced by the time of trial, given that she told this story, that she must have really been jealous and angry at him, and insisted to his lawyer that he cross-examine her on this topic because he felt that it was the only reasonable explanation for why she would make up a story. What defense counsel told the jury was that
she was mistaken.
She was mistaken, that the conversation doesn't exist anymore, and it was her interpretation of the conversation. But what I suggest to the court is that this is not the type of conversation you're likely to be confused about if your friend, in quotes, tells you that he had sex with another woman thinking that it was his wife, and she told him to stop. And that, I don't know what about that you would be confused about.
I'm sorry to interrupt you. Can we infer, based on that account that you've just stated, in answer to Judge Singh's question, that the conversation must have happened years earlier? Didn't the defense counsel argue that it was so long ago, that's why her memory may not be accurate?
Yes, that he did argue that. And I wish I could put a better time frame on it, but it was, all I can recall from the record, it was after she had talked to the police. And probably at least months before she recounted this conversation to the prosecutor. So, you know, I mean, we all have our personal experiences in life. And for me, jealousy is an enormous motivator. I quote William Penn on this topic. And I just don't see the other side of this issue. I don't see the downside from suggesting that she has a motive to fabricate. The defense lawyer said it was something like, he thought it would increase her credibility because she had had an intimate relationship with this person. I just don't see that. I don't see how a reasonable person would assume that if you had an intimate relationship that ended when the man walks out of the relationship and gets into a relationship with somebody else, that would be a motive to make you more credible. It seems to me that's the standard concept of jealousy.
Didn't it go beyond that, though? Didn't it go to the extent that, by all accounts, that they still remained friendly, as evidenced by them getting together shortly before trial, that now you would have two women who arguably were scorned by the defendant and thus fabricated these stories? Didn't he think that wasn't so powerful at trial?
So, no, so I don't see how the addition of a second woman, quote unquote, scorned, Your Honor. I mean, it makes him seem like more of a Romeo than perhaps you would think at first blush. But she never claimed, Melissa, that he had sexually assaulted her. So I don't see how it.
Well, the argument was he left her for his wife.
Right. And if in fact she didn't, this conversation didn't take place, which is what the defendant maintained and swore in an affidavit that was introduced into evidence, and defense counsel never questioned the factual accuracy of that. He just thought it would boomerang by increasing her credibility with a prior sexual relationship. I find that mysterious in my personal life, the idea that would result in more credibility. I think it leads immediately to the view that there could be a lot going on here that would.
Well, maybe not so much more credibility for the victim, but wouldn't it impress upon, you know, the picture that you're starting to get of this defendant? If this is yet another woman, you know, there's three women in this little scenario that's put before the jury that he's having sexual relations with. I mean, doesn't that sort of smear him? Like you said, make him more of a Romeo, as you put it. But
so I think it does make him more of a Romeo, Your Honor. But Melissa Shaw doesn't claim there was any sexual assault. His wife doesn't claim there was any sexual assault. The only person that's claiming a sexual assault is the alleged victim, who has a motive, which is that if you believe the defendant's story, that she slept with a colleague's husband, and in fact, the first person she reports it to is another colleague, and there is a confrontation between the women. So it seems to me it makes him more, the more Romeo he is, the less rapist he is, as opposed to the other way around.
So with respect to the reasonableness of the strategic decision, the lawyer seemed unsure or wasn't certain of his assessment, and he spoke to his supervisor about it, correct?
That's correct, Your Honor.
And his supervisor seemed to agree or concur that perhaps the consensual, hostile former girlfriend, I don't mean consensual, but the hostile former girlfriend wasn't really the best strategy to go. And perhaps we should leave that bit about the consensual sex that they had out of it. So the supervisor supported his final decision, is that right?
That's correct, Your Honor. And so in response to that, I would say I've made some really, really stupid decisions at trial. I mean, really stupid. And the fact that I consulted with another equally foolish person about that decision doesn't necessarily mean that that decision has any merit to it. It just means that two of us were foolish. Now, I compliment any trial lawyer that is concerned about whether a strategic decision makes sense or not if he or she consults a colleague. But that doesn't make it objectively reasonable. Just,
No.
You can consult. I could find 20 lawyers to consult, and I would have 20 lousy answers.
Sure. And then the trial court heard the same argument on motion.
Correct.
And he thought that the tactical decision was reasonable.
That's true.
So we're up to 3.
Right. But the only 3 that matter right now is the panel I'm in front of.
Okay.
So unless there are further questions, I feel you understand my argument, and I've had a chance to say what I wanted to say.
Panel, any other questions? Seeing none, we can hear now from Attorney McGee. You just want to wait a moment. I think you'll get your timer. Or maybe, yes, there we go.
Good morning, and may it please the court, Michael McGee for the Commonwealth. Here, the judge, who was also the trial judge, properly exercised his discretion in denying the defendant's motion for new trial based on ineffective assistance of counsel. Attorney Williams made a strategic decision, questioned the accuracy of Shaw's statement rather than impeach Shaw with the prior sexual relationship because they remained friends. It was reasonable for Attorney Williams to impeach Shaw with evidence that she deleted the alleged Facebook chat conversation and the entire account. There was no objective evidence that Shaw was jealous of the defendant's marriage. The judge correctly ruled the defendant failed to meet his burden to show that he received ineffective assistance of counsel or that justice was not done.
Can you enlighten me as to, it was unclear to me from the record as to what prompted this disclosure shortly before trial?
From the record, it was a stipulation that 3 months after that Shaw had been interviewed by Sergeant Kingsbury, that she had this conversation with the defendant, but it was not disclosed until 3 years after the conversation with Sergeant, or the interview with Sergeant Kingsbury shortly before trial.
All right, so there's nothing that explains the disclosure shortly before trial.
No.
Thank you.
Not in the record.
Do we know whether or not she reached out to the police or the police happened to reach out to her with respect to the disclosure shortly before trial? When we say shortly before trial, what was it, like a week and a half before trial? Is that right?
It was, I'm just going to read the stipulation here. The stipulation that was presented to the jury as an exhibit at trial did not specify the exact date, but it was before the motion judges to it being 3 years after the conversation with Sergeant Kingsbury.
And the second part of the question was, do we know, had she reached out to the police or did they reach out to her, if you know?
I don't want to speculate. I have a memory from the motion, in preparation for the motion hearing, that this was brought to the attention of the Commonwealth shortly before trial and witness preparation. But I may be wrong, and maybe that would require 16-11.
So your brother makes a pretty good point that, you know, jealousy is an awful strong motivator to fabricate or to seek revenge in some sort, if that's the proper word. What would the downside have been, if you could articulate for us, if he had pursued that strategy rather than she forgot and was mistaken and erased all the accounts?
Well, according to counsel, the trial counsel at the hearing, motion for new trial hearing, it was speculative, and it wasn't entirely clear that she had done this for revenge. It was more posed as a hypothetical. Maybe she's doing this for revenge. Additionally, they were friends. They were speaking up until the trial. They met at a McDonald's shortly before the trial, and they remained friends at trial. The backfire here is that now he's at trial. The defendant is asking the jury to credit him in a way, but he's now discrediting two women, and that would backfire. The strategy was strong. This is a conversation that happened 3 years before, and mysteriously a social media profile no longer exists. And it was simply an impression that she had about a conversation. So it wasn't a conversation that was given to the jury as a physical exhibit or anything like that. This was Ms. Shaw's impression of a conversation that happened 3 years before. She failed to bring to the police's attention, and mysteriously the conversation no longer existed, and her account was deleted. I would suggest that the competent and experienced defense attorney, who did bring this to the attention of his supervisor, who was very experienced, was a very appropriate, and it certainly wasn't manifestly unreasonable.
So the strategy was to devalue this particular piece of information rather than increase its value by going on this all-out jealousy theory.
Correct. That didn't have any objective credibility to it. And there wasn't, they were friends. They were still, they being the defendant and Ms. Shaw were friends up and through the trial. As I suggest, the backfire here is that he's accusing two women of lying at trial. Unless there are further questions, I would rest on my brief and ask you to affirm the conviction and affirm the denial of the motion for new trial. Yes.
Panel, any further questions? All right. Thank you very much, counsel.
Thank you.
Have a nice day.
And we wish you a very safe and healthy balance of 2021.
The case is now being recorded.
Good morning, everyone, and welcome to the March 9th sitting of the Massachusetts Appeals Court, March 9th, 2021, that is. My name is Mary Thomas Sullivan, and your panel today will consist of me, Justice Desmond, and Justice Singh. Our oral argument on this remote platform will follow all the usual rules normally employed in the courtroom. That is, each side will get 15 minutes and there will be no rebuttal, and the attorneys are encouraged to get to the heart of their argument. You can rest assured that we are familiar with your briefs and your arguments. We hope there will be no technical issues today. If by any chance there are any, we will make sure that everybody gets their 15 minutes. And for those of you who may be watching this on live stream or recorded, if it is necessary for us to go offline to fix a technical issue, we will, but rest assured that we will return. And finally, if you happen to see me or anyone else look to one side or another, it is not in intention and we mean no disrespect. It's just that we may have our other case materials to one side of the camera or another. On the bench, it doesn't look so obvious, but on this Zoom platform, it looks a little different. We're just referring to our materials so we can ask our next question. And with that, we will move on to 19P 1637, Commonwealth versus Joseph R. Cooper, and I believe Attorney Deal, you are up first.
Yes, Your Honor, thank you. Good morning, Alexandra Deal for Mr. Cooper. This is a case in which the evidence was insufficient as to each of Mr. Cooper's convictions. If the court has a preference with respect to which argument I address first, I'm happy to oblige, but otherwise I'd intended to address the firearm first, followed by the narcotics. Now, because this is a case of constructive possession, the Commonwealth had to prove more than mere presence in the automobile in order to make its case. That is, it had to put forth evidence of some other incriminating factor or factors that would show that Mr. Cooper both had knowledge of the firearm that was in the car and an intent to exercise dominion and control over that firearm. And the Commonwealth fails with respect to the first prong, which is knowledge. As you know from the facts, the gun was found in the doorwell of a car that was not Mr. Cooper's. It was concealed in a sock, so it was not in plain view. There was nothing tying Mr. Cooper to the car. That is, there was no, there were no documents, there were no personal items, nothing that would indicate that Mr. Cooper regularly used the automobile or had any particular knowledge of its contents, such that, and of course, Mr. Cooper himself was cooperative when the police, detained him and began searching him.
How long was he observed to be with or operating that motor vehicle on that particular date?
I'm not sure of the exact time frame, Your Honor, but there was certainly a series of events in which the police were following his car through various neighborhoods of Boston before actually apprehending him in the parking lot of a Shaw's in West Roxbury. So I think the events transpired over maybe the course of an hour or so.
Go ahead, judges.
Well, we know at one point he stopped, got out of the car, went in, had lunch, came back out, got in the car, drove a little bit further. And in the course of them following him around, he had made two separate stops, one in Boston and one, I forget what the second one, I want to say maybe just on the outskirts of Boston, but I forget exactly where the other one was. The car belonged to his mother and was registered to an address that he lived at.
Your Honor, I believe it was actually registered to his mother's address. So his mother was at 27 Spring Street, and that's how the police initially identified the owner of the motor vehicle as Mr. Cooper's mother. And then as the officers testified, they ran some reports. I'm not entirely clear what it is that they were looking for, but they located her and her address. They somehow then tied her to Mr. Cooper's father, who has the same name, but a different address. He's at 25 Spring Street. And the younger Mr. Cooper, the defendant here, lives at that address as well with his father. So they made the connection that way.
And what initiated the surveillance? Was it the first stop with the lady from the housing complex who came out, or was it the actual plate that they were familiar with for possibly engaging in other drug conduct that was associated with a different car, a dark Mercedes?
It appears from the record, Your Honor, that it was the latter. It was that they somehow took notice of the plate itself because it was associated, as you said, with a car that they had information on. So they had not actually at any point in time prior to that linked the car to actual drug transactions, but they had information that a dark Mercedes bearing that license plate may have been engaged in drug transactions. So somehow that plate caught their eye and thus began the surveillance. Yeah.
There was a little bit of an interesting tussle at trial, was there not? Correct me if I'm wrong, where the prosecutor was afraid that the pro se defendant was about to go down that road of what their prior suspicions were and had attempted to curtail the pro se defendant's examination.
That's correct, Your Honor. Yes, there were perhaps a few of those incidents at trial, right. In which, because he was a pro se defendant, there was certain evidence he wanted to bring out, or he thought would be helpful to his case, that he wanted to bring out. That is correct. But I think that,
if I may, just one other matter on background. Was this an inventory search that led to the seizure of the gun?
It was, Your Honor. Yes.
All right. And the stop was challenged on a motion to suppress. We don't have any of that. I see it's not on appeal, but it's undisputed that this is an inventory search and not some other form of search. Am I right?
That's right, Your Honor. Yes,
Okay.
it was an inventory search. But obviously in this case, what we're looking at is the totality of the circumstances. I know, the sufficiency of the evidence is a very fact-specific inquiry. And I would say here, with respect to knowledge of the firearm itself, the Commonwealth just came up short.
Doesn't Commonwealth v. Craps cut against that argument?
I don't think that it does, Your Honor. In Craps, the defendant was the driver and sole occupant of the car, but there was evidence, first of all, that it was his girlfriend's car and she had let him borrow it for some time. So there was evidence linking the defendant to that car as the driver of that car for multiple days. He also had personal items, I think, in the car that tied him to the car and that showed that he would otherwise have had knowledge of the contents of that car. And that's not the case here. It's obviously his mother. So we do know that there's some connection to the car, but what we don't know is if he put the plates on 5 minutes before he started driving the car. There's no evidence that he had any particular, exclusive or continuous use of the automobile, which was the case in Craps. And in Craps, I believe also there was some collateral conduct that alerted the officers to the defendant's knowledge of contraband in the car.
Well, don't we have that here? I mean, Craps kind of stands more broadly for proximity, access, and collateral conduct. And here we have the sole occupant of a car. Here we have belonged to his mother, which ties him arguably to the car. And then we have the proximity to the gun. It's on the left-hand side in the vehicle, with only next to the driver, clear access to it. And then the collateral conduct, the observations of the police who believed or perceived this conduct to be engaging in drug activity, and then some expert testimony from the Commonwealth about how drug deals or drug dealers protect the trade and act.
I agreed with you up until the collateral conduct
Okay.
part, and it's that I don't agree with for a couple of reasons. One is that those interactions alone I don't think are indicative of anything in particular, because the police never in fact stopped either person that Mr. Cooper was interacting with. So we don't know what those interactions were. Were they potentially indicative of drug transactions? Sure, but were they potentially indicative of innocent conduct? Yes.
Couldn't they add that to the evidence regarding, the other car with the note with his name in it and a telephone number, and the testimony regarding the significance of sort of using one car or using another car that's not in his name, putting those two together?
They could, although I don't think that other car was ever specifically identified as his car at trial, nor was it identified as the car that people saw driving in the neighborhood. But I also want to just jump back to that, because if in fact there was evidence that Mr. Cooper may have been engaging in drug transactions, potentially as a purchaser, and obviously that goes to the argument with respect to the sufficiency on possession with intent to distribute. But even if there were that doesn't necessarily show knowledge of a firearm in the motor vehicle. I don't think the Commonwealth has pointed to a case, and I was not able to find one, in which simply because a person may or may not have been engaging in suspicious activity, that alone indicates that he would have knowledge of or the intent to exercise dominion and control over a firearm that was in the car.
But it strengthens the inference that the car is being used specifically for this purpose. So it wasn't a happenstance, I'm going to borrow my mother's car today, and then my mom's got a gun and a sock in the drawer, but that he went out, he selected this car for this specific purpose for the drug dealing. And doesn't that strengthen the inference?
I think it's a possible inference, but I think that it's one of those inferential leaps that is impermissible when you're dealing with the overall sufficiency of the evidence, especially because there's nothing else here. I mean, first of all, we don't know, was that Mercedes inoperable, or was the dark car inoperable such that he needed to switch the plates for that reason? The Commonwealth just fell short here in terms of putting forth evidence that would show these elements beyond a reasonable doubt. And I guess I can move on to the narcotics piece of this, because I think we've already touched on it. Although I will say, with respect to the loaded firearm, I mean, obviously, if the court finds that he didn't constructively possess the firearm, then obviously he didn't constructively possess a loaded firearm. But I think it's very important here that the court acknowledge the fact that this gun was concealed in a sock. And so unlike the case that the Commonwealth cites, this isn't a case where it would have been readily apparent to anybody that the gun was loaded, because the gun was concealed. And this is like Grayson, there's no evidence from which someone could infer that the defendant would have checked the gun to see that it was loaded. So I just want to make that brief point. I would like to move on.
Before you move on, the firearm indeed was a revolver. So it's distinguished from perhaps an automatic, where you can't just visibly look at the gun and determine whether it's loaded or not.
It is, but I think that it's important that it was concealed, and that's why Grayson is an important case for the court to look at, because in Grayson, the gun was similarly found in a sock. So the idea is that if it was found in a sock, then that makes it much more difficult for anyone to infer, unlike a case where the gun is on the defendant's person, for example, that he would have checked it to see if it was loaded. And so that is yet another sort of inferential leap that is one that I think can't be made here, or would have to be made, frankly, in order to find that the evidence was sufficient. And this reminds me that I did want to point the court to two cases which are in the defendant's reply brief, but I think Justice Desmond, you pointed to Craps, but I think these two cases are actually much more analogous in the context of constructive possession, and that's Commonwealth versus Nguyen and Commonwealth versus Crisafulli. Both of those cases are unpublished opinions. However, particularly Nguyen has a very, very similar fact pattern. The defendant is driving his mother's car. There are narcotics found on the floor of the car, and there's a loaded gun that's found in a bandana in the glove compartment of the car. But the court ultimately found, based on those facts, that there wasn't enough evidence to show that the defendant had constructive possession of the gun. So again, acknowledging that it's an unpublished case, I do actually think that case is far more similar to the facts in this case. Now, with respect to the narcotics, this is, and I acknowledge this, a much closer case, I think, than the constructive possession, which I would argue is actually a fairly clear insufficiency case. But with respect to narcotics, I think the key issues here are the defendant didn't have a large quantity of drugs on him. He didn't have a large quantity of cash on him. He didn't have any accoutrements of the drug trade on him. And he didn't have anything that would indicate, other than that he possessed these drugs, which of course there's no argument he didn't possess them. They were on his person, that he possessed these drugs with the intent to just, pardon me?
But there were three, I'm sorry to interrupt you, but your time is brief. So I just want to ask you this. There were three different kinds of drugs though. There's oxy, there's crack, and there's powder cocaine. Does that permit an inference of distribution?
I don't think it does, Your Honor. I mean, there was no testimony that, drug users don't use different types of drugs. This was, in each case, a very small amount of each drug. Nothing about the packaging was distinctive. I mean, you can actually look at that in the record. There are pictures on, I think, 36 and 39 of the appendix. You can look and see that the little baggies are tied differently. And the Commonwealth points to the fact that there was an absence of drug paraphernalia, but that was also the case in Cepheus. And I don't think that alone supports an inference that Mr. Cooper was selling rather than purchasing the narcotics. I think this is a classic case in which it could be either.
But as in Cepheus, the evidence was admitted properly or not, of the police officer saying that he believed he saw a drug transaction, and in Cepheus, that was enough to show that the evidence was sufficient.
But there certainly is no question that the officer may have witnessed a drug transaction, but the question is who was the buyer and who was the seller. And that's something that the Commonwealth never established, because they didn't stop either of the people who entered Mr. Cooper's, or who interacted with Mr. Cooper on that day.
Thank you very much. Are there any other questions from the panel? Okay.
Thank you.
Thank you. Attorney Wakeford.
Good morning. May it please the court. I am ADA Donald Wakeford, and I represent the Commonwealth in this matter. This case is a prime example of how every inquiry into the sufficiency of the evidence is hyper-specific to the facts in the specific case. This case is emblematic of that, because we have a sequence of events at before the arrest itself and at trial that are just not going to be duplicated in any other case. Even in cases such as Nguyen, which is cited by my colleague in the reply brief, where there's similarities, such as the defendant borrowing his mother's car, there are several distinctions between this case and Nguyen. I think the important thing to focus on with this case is looking at the standard that this court is expected to apply for the sufficiency of the evidence, viewing the evidence in the light most favorable to the Commonwealth, and determining whether any qualified jury could have rendered the verdict that it did. We look overall at the picture that was painted for the jury, which I think was run down pretty comprehensively by Justice Desmond just a few minutes ago, where they were confronted with evidence that the defendant was the sole occupant of a car, which was registered to his mother, where he had proximity and access to a handgun, which was inches away from his left knee for several hours. I believe there was a question about time. I believe it was about 2 hours that he was observed. So this gun was mere inches away for several hours. The observations of police, the defendant was engaging in transactions which expert testimony described as likely drug transactions. And then later, through questions of the defendant, there were opinions rendered explicitly that these were drug transactions that the police observed. And then finally, yet the rest of the expert testimony as to what all of this means in context, including expert testimony that drug dealers occasionally, or drug traffickers, will change license plates on vehicles in attempts to foil police investigations into their conduct. With all of this put together, the question is whether it was reasonable for the jury to draw the inference that the defendant was aware of and intended to control the handgun, which had been sitting right next to him for that extended period of time. I think that looking at the evidence holistically and putting it together, the question is whether not these individual inferences can stand on their own to tip the case in any way, but whether together they paint a picture which can support the jury's verdict. And I believe that viewed together in the light most favorable to the Commonwealth, the evidence does exactly that in this case.
How do you distinguish Nguyen?
Nguyen had a situation where another individual was seen hanging outside of the car that the defendant was in, and then was seen to drop something in the vehicle after he got nervous and noticed the police. The other individual walked away. The defendant was the person sitting in the vehicle in his mother's car, and he was arrested when I believe the bag contained either ecstasy or some other narcotic, and then a search revealed that there was a gun wrapped in a bandana in the center console. So there we had the activities of another person who had actually been holding what were purported to be the drugs, so the association of the defendant and the drugs was more tenuous in that case. Additionally, the defendant was only seen sitting in the car. In this case, the defendant was observed for multiple hours driving around, stopping to have a meal, have a conversation on a cell phone, return to the vehicle, drive another distance, and then be arrested next to another car that had his name and phone number inside it and that may have been associated with the change in license plates. So there was just a lot more evidence in this case, again, hyper-specific to this case, that indicated that the defendant here had control and knowledge of what was in the car, his mother's car, as opposed to Nguyen, where all they really had was the defendant sitting in his mother's car while this other transaction or exchange took place. So I think that distinguishes. There's just more. and especially when put together with the other facts in the case. We just have a picture where the jury was essentially asked to determine whether it was reasonable to draw this conclusion that this car was being used by the defendant to sell drugs, and that therefore he did know and intend to control the gun right next to him. With regard to the drugs themselves, the drugs were individually packaged, and there was expert testimony that in order that buying crack cocaine in the fashion that it was packaged on the defendant's person would be akin to a person buying 12 individual slices of pizza instead of a whole pizza. It just doesn't make any sense. And when you couple that with the observed interactions of the defendant, the expert testimony giving context to what those interactions were, and the lack of user paraphernalia on his person, I think the jury's the jury's conclusion there was authorized as well. And finally, although it was not addressed during my colleague's time before this panel, the judge and the prosecutor in this case each went to lengths in order to ensure that the defendant received a fair trial after he elected to represent himself. I think the defendant had an idea of what he wanted to present to the jury. That seems to have been a large part of the reason why he elected to represent himself after opening statements were made, and that the defendant was going to doggedly pursue the lines of inquiry that were important to him in his own case. And the judge in this case, Judge Locke, advised the defendant against the dangers at one point of opening the door on cross-examination. At another time, stopped the defendant and said, "Are you sure you want to ask that question?" When the defendant responded yes, and proceeded. And at another point, a police witness turned to the judge and said, "Should I answer this question?" Additionally, the judge advised the prosecutor after some material came in that otherwise maybe would not have because of the defendant's questions on cross. The prosecutor rose for redirect and was told by the judge explicitly, "Do not exploit this defendant." The prosecutor responded, "I had no intention of doing so," asked 2 questions regarding that information, and then did not pursue it until closing argument. I think taken together, the evidence in this case was sufficient to authorize the jury's verdicts, and that the judge did not err in his oversight of this unusual and hyper-specific case. Unless the panel has any other questions for me, I will yield my time.
Panel? All right. Thank you both very much. Excellent arguments on both sides. And we do wish you, as 2021 progresses, a safe and healthy balance of the year. Thank you.
Thank you.
Thank you, Your Honor.
Being recorded.
Good morning, everyone, and welcome to the March 9, 2021 sitting of the Massachusetts Appeals Court. My name is Mary Thomas Sullivan, and your panel today will consist of me, Justice Kenneth Desmond, and Justice Singh. Our usual rules of oral argument apply in this virtual setting. Each side will have 15 minutes in which to argue, and there will be no rebuttal. And counsel is encouraged to go to the heart of your arguments. You can assume that we're well familiar with your briefs. For those of you who are watching, if we have technical issues, we will do our best to resolve them quickly. If for any reason we have a bigger problem and we need to go offline, we will. Don't worry, if you lose our feed, we will be back. And for everyone involved, if you notice me or anyone else on the panel look from one side or the other, please, it's no sign of disrespect and it's not inattention. We're simply looking at our other materials, our screens or our briefs, so that we can respond to your argument as best we can. The next case is 19P1778, Murphy versus Commonwealth. Attorney Coase.
Thank you, Your Honor, and good morning, Your Honors. May it please the court, Matthew Coase on behalf of the petitioner, CONRAD Murphy. I want to start out my argument by addressing kind of the big issue that had many different, it kind of manifested itself in many different aspects of the trial of this case. And that was Mr. Murphy's refusal to participate in sex offender treatment. And we've kind of broken this down into several subsections for the court, and I want to try to address each one of those. First and foremost, I want to just kind of give the court an overview of kind of the constitutional implications that are associated with the refusal of treatment. We believe that the Section 9 and the statutory scheme in place kind of creates a situation where the civil committee is required to basically engage in this treatment. Under the statute, it's either participate in the treatment or don't participate in the treatment. And as a result of participation in the treatment, they're required to waive confidentiality, talk about offenses, potentially talk about offenses for which they have not been charged or convicted. And that creates a situation where they're almost compelled into.
Counsel, didn't the SJC already reject the compulsion argument in Hunt?
It rejected the compulsion argument in the Hunt case with respect to Section 12 cases, the initial commitment cases. But we suggest that the scheme which forces the civil committee into treatment kind of gives them the option of either entering into the treatment and waiving confidentiality, or basically giving up any real prospect that they would have of being released under the statute.
I don't really understand what the distinction is between a Section 12 case and a Section 9 case. And my confusion on that topic cuts against you on the constitutional issue, but it might cut for you on the other grounds of exclusion that the SJC identified. And so I'm curious as to both counsel in this case, because you're both arguing that recommitment is different than initial commitment for purposes of this evidentiary issue. And I'd like you to explain why the possibility of being recommitted for a day to life is any better or worse than the possibility of being initially committed for a day to life.
Well, I certainly wouldn't suggest that it's any better or worse. I think it's the same outcome one way or another.
Then why does Hunt not fully apply?
Well, I suggest that Hunt fully does apply, Your Honor. And I think the reason for that being is, the Commonwealth can certainly argument that there's a lack of participation in treatment, but it's the refusal component is what's so prejudicial to the petitioner. And the refusal is, on the flip side, would not be prejudicial to the Commonwealth, because they still have the opportunity to argue the treatment and the lack of participation in treatment. But when you get to the heart of what the petitioner is trying to prove or defend against is this idea that they can never be cured of this mental abnormality. And it's not necessarily the case that all mental abnormalities have to be cured or can only be cured by treatment. But
in this case, they're talking about sadism. Is that correct?
That's correct, Your Honor.
And they point to that one specifically to say that is one that has to be treated in order to be improved.
Right, but the other requirement that is announced in Hunt is that there has to be kind of this empirical evidence associated with those opinions. So in this particular case, and I think I do a better job in my reply brief trying to articulate the point, but there has to be some sort of explanation of how much that treatment would have helped in order to reduce or show that the lack of treatment has caused him to continue to be sexually dangerous. In other words,
if I might, just for a moment, if we were to conclude, and I'm not saying we would, but if we were to conclude that Hunt applied and therefore evidence of refusal was inadmissible, did any of the experts talk about refusal, or did they only talk about lack of participation?
I think they spend quite a bit of time talking about refusal.
Experts or the prosecutor?
The experts. We're starting with the experts.
Yep. I think that there was.
I didn't see it. Now, it doesn't mean it isn't there.
Okay. Well,
Can you point us to it in the record?
Pardon?
Can you point us to it in the record?
Not at the moment, Your Honor. I'd be happy to review the record and get back to the court if it.
A 16L letter that just has the cites and no argument would be permitted. To go to Judge Singh's point, then, Hunt reversed, not based the error in the admission of refusal evidence did not in and of itself result in a reversal in Hunt. Where is the prejudice in this case? If you're right.
Well, I think that the prejudice arises in a number of ways. I think it arises from the counsel's opening and closing argument, as I had mentioned before, and I think that, in my view, kind of turns the burden of proof on its head.
Leaving aside the burden of proof, do you have a case that says, I know there were repetitive references to refusal in the opening, at least. What's your best legal case from our court or the SJC for the proposition that coupled with the evidence that you claim violates Hunt gets you a reversal?
Your Honor, I don't believe that there's any cases out there that speak directly to that issue. I know that there's a 128 opinion that I had cited in my brief. I think it's really there's a lack of case law about this, so I would suggest that Hunt is probably the best decision. I've also pointed out to the court that there is a case involving the Sex Offender Registry Board, in which the SJC has kind of extended the rule from the SDP context into the Sex Offender Registry Board context. And I think that I don't think it isn't binding on this court, but I think it gives this court a hint that the SJC didn't really intend the Hunt case to be so narrowly construed only to Section 12 cases. In the Sex Offender Registry Board case, they actually talk about the offender refusing to talk or refusing to enter into treatment because he was afraid that it would be used in the Section 9 case. So I think that is indicative here of, or indicative that the court didn't rule out, pre-commitment versus post-commitment treatment.
At some point, doesn't your client agree to allow the refusal evidence?
He does, Your Honor, and I think there's really he didn't have much of a choice. It seemed as if the court was going to allow it in, and it seemed that he took the strategic choice that if it's going to be allowed in, I at least want to be able to kind of give my explanation for it to be so that the jury can understand. And obviously that had to do with the fact that he was challenging his convictions through Rule 30 motions I believe he had one appeal pending on the governing offense, and had expressed his intention to file a Rule 30 or an appeal on the one of the other offenses. So, and I think he felt strongly, and I think that came through with the arguments from counsel, that he felt that he would be undermining his appeals if he were to enter into treatment and have to talk about his offenses, and in other words, confess to those offenses. And I think he's got a dilemma here that he has to deal with. Does he undermine his appeal, or does he enter into the treatment and force the issue to try to get released on Section 9?
Option choice.
It really is, Your Honor, and I think there is another avenue, which is simply not another avenue that's less intrusive to the petitioner, and that's allowing the evidence in of lack of treatment without specifically getting into the details that he's refused and the reasons for his refusals, because that is so prejudicial.
Was there any pretrial discussion about that proposition?
There was, Your Honor. I think it was, it wasn't in specific, Fifth Amendment terms or constitutional terms, but I think they did talk about incrimination in the pretrial discussions of the motions in limine.
Specifically, lack of participation versus refusal.
Yes, Your Honor. And so, I mean, I did point out to in the reply brief a couple of issues or a couple of cases relating to why this issue hasn't been waived and why it can be raised for the first time on appeal.
Well, I think you're saying it's not raised for the first time on appeal, that he raised it and lost.
I'm sorry, Your Honor.
I thought you were just saying that these were raised in motions in limine.
They were raised on motions in limine, and even if the court does not feel that the constitutional issue was raised, that there's ways around that. The other, I see my time is starting to get a little bit low. So the other issue that I did want to bring in is with respect to the social worker evidence. It appears that the trial court sought to or excluded portions or a large portion of the social worker's testimony and her report. And I think that this kind of speaks to the Santos case. In the Santos case, the court talked about kind of this fairness between the ability to present evidence. So Dr. Johnson, the CAB representative, spoke about Mr. Murphy not having a release plan. And I think that Mr. Murphy should have been given the opportunity to confront that evidence and use Ms. Patz's testimony and report to demonstrate that he had put together a thoughtful release plan, as opposed to just talking about these general release options that were available to her or to him, which is what the trial court really kind of only allowed Ms. Patz to do in those circumstances.
And so how was her testimony specifically restricted?
Well, I think counsel wanted the social worker in order to give kind of an expert opinion, if you will, about how certain programs would be tailored to fit Mr. Murphy and how he might thrive in a particular program versus a different program. And certainly Ms. Patz is an experienced social worker and has experience doing these release plans. And I think that she could have spoken to why the release plan that Mr. Murphy had put together was suitable.
So he was allowed to get out that he had a plan, correct?
There was some cursory discussion about that, I believe, during cross-examination of Dr. Johnson. And Ms. Patz did bring out that there were options available to him. And I think, Mr. Canavan's testimony spoke to that as well. But I think, and I see I'm out of time, so I'll wrap it up real quick here. But in these cases, we allow petitioners to go in and obtain funds for social workers so that they can put together these release plans and have information available to them. So I don't think it really makes sense to give funds and allow a social worker to work on the case if they're not really able to provide an overview of what their work entails and how it would affect a specific petitioner.
All right. Are there any further questions from the panel? Okay, Attorney Mansfield.
Morning, Your Honors. May it please the court, Brian Mansfield for the Commonwealth. As Justice Desmond pointed out, in the pretrial motions, Mr. Murphy's counsel did agree that evidence of Mr. Murphy's refusal to enter treatment could come into evidence as long as he was able to explain the reason was that he was challenging his convictions.
But that only occurred after a fairly emphatic denial of the motion in limine by the judge, right?
No, the judge had indicated that she would let the fact that he wasn't treated in, and she found that there was a difference between the Section 9 context and the Section 13 context, but that agreement did not come. She was in the middle of a discussion with attorneys. The judge was in a discussion with the attorneys as to whether she would allow the refusal in. She'd asked the Commonwealth what was the probative value of the refusal. And it came in the course of that discussion and in a discussion of the appeals that Mr. Murphy had pending, that Mr. Murphy's counsel indicated to the judge that he had just spoken to Mr. Murphy and he had a solution. So the judge had not made her ultimate ruling whether the refusal itself would be entered into evidence. When
she had though said she thought that a Section 9 proceeding was different than a Section 12 proceeding, right?
Yes. And the reason for that is because in a Section 9 petition, the petitioner is somebody who's been found to be sexually dangerous and is being held specifically for rehabilitation and sex offender treatment. In Hunt, the court was discussing prison-based sex offender treatment in an initial commitment case. And there is a difference between the evidence that is available to the experts in an initial case and in a Section 9 case. Section 9 is a much broader description of what records are available to the forensic evaluators, where it says the qualified examiners in the cab, where it says they are all records are available for their review. And so the petitioners like Mr. Murphy have no expectation of confidentiality in the sex offender treatment. As a matter of policy, the legislature has deemed that it is not confidential by allowing all of these records to be available to the forensic evaluators, including all of their treatment records. So you have a completely different situation than you had in Hunt, where somebody in Hunt, Mr. Hunt was serving a criminal sentence while he was in the sex offender-based treatment in a prison. Mr. Murphy, on the other hand, has been specifically committed for sex offender treatment and rehabilitation. So it's quite a different situation. And again, the records available to the forensic evaluators is much broader in Section 9 sense than it is in a Section 13.
Section
Also,
12. You mean
Section
Section 12?
Yeah, they call variously 12 and 13. It begins with Section 12. The trial is under 13, I believe.
Okay.
And the whole purpose for a Section 9 petition is to see whether, or have the Commonwealth needs to prove that the mental conditions that existed continue to be active in the present. And the only way to do that is by a review of treatment to see how somebody has progressed in treatment, whether they've treated these mental conditions that are considered to be persistent and lifelong. And in fact, in the Hill case, the SJC in a Section 9 said it was an appropriate avenue to prove this by showing that a mental condition was something that persisted, did not go away without treatment. There is no cure, but somebody can learn to manage it with treatment. And that showing that somebody had refused treatment that would help them ameliorate that condition was a perfectly appropriate way for the Commonwealth to prove its case that the individual continued to be a sexually dangerous person.
Doesn't the prejudice discussion in Hunt similarly apply in a Section 9 context?
I don't think it does because of the difference of the, not only the proceeding, but because Mr. Hunt was in a prison-based sex, or they were discussing the confidentiality issue in a prison-based sex offender treatment program. The jury is not going to necessarily know in a Section 9 or in a Section 12 that sex offender treatment was available to, in this case, Mr. Hunt. You know, in the Hunt case, they're not going to know that that was available to him. But in a Section 9, based on all the evidence that he was, and the instructions to the jury that Mr. Murphy in this case was committed for specifically sex offender treatment and rehabilitation, for the jury not to understand why he was not treated, that turns the probative value versus prejudice back to the Commonwealth's favor, because a jury may very well believe that, well, this man's criminal sentence is over. He has been committed for sex offender treatment, yet he has no sex offender treatment. They may speculate that here he is being committed and they're not offering him sex offender treatment. So I would suggest that the probative value, based on what I discussed before about proving that the mental condition still exists, outweighs the prejudice, and that there is prejudice to the Commonwealth with a jury to believe that he was not being offered sex offender treatment, even though that was the sole purpose of his commitment.
That was a risk in Hunt as well. And the SJC was very, very clear about this. It says in Hunt, in language that does not appear to be limited to Section 12. I hear that you're now drawing the distinction, but the SJC said that conditioning sex offender treatment and confidentiality is problematic because statements regarding sexual conduct, proclivities, and thoughts made available to those who may choose to use such statements to prosecute him for past sexual offenses, deny him parole, or commit him indefinitely as an SDP. That is the evil that the SJC identifies in Hunt. And it goes on to say the required waiver of confidentiality not only poses a substantial risk that a prisoner's statements during sex offender treatment will be used against him at a criminal trial, parole hearing, or SDP civil commitment proceeding, but also if sex offender therapy is akin to psychotherapy, is likely to impede the development of an atmosphere of confidence and trust, chill the candor of communication, and diminish the likelihood of successful treatment. Why is that not fully applicable in a Section 9 proceeding? Why are those policy considerations not fully applicable under Hunt, which we are bound to follow?
Again, because Hunt, and every time the SJC discusses the treatment program, they do preface it with a prison-based sex offender.
But what to me, what's the distinction? What's the difference there?
The distinction is that Mr. Murphy he's not penally sentenced for a crime.
But why does that matter?
Because he's civilly committed specifically for sex offender treatment.
Right, but the SJC has already said that they're concerned about the use of this evidence in an SDP proceeding. That is in their list.
Well, certainly things that Mr. Murphy may have discussed in treatment can cut both ways. They can certainly help him to prove, not to prove, but they can show that he has participated in treatment, and the evaluators can look at it and say, well, he's discussed his issues, he understands what his issues were, he has developed intervention. This goes towards the whole likely to reoffend.
We understand the claim of the beneficial nature of the treatment. That's not what's at issue here. What's at issue is whether or not the petitioner in an SDP proceeding can be leveraged by having refusal evidence go in rather than evidence of non-participation.
And again, I go back to the difference of the statutes and the fact that the Hunt was decided on the more prejudice than probative formula. I think the Section 9 flips it, because as I said, the jury learns that this is somebody who has completed their criminal sentence. They have no penal sentence facing them. They've been civilly committed for treatment. And for them, that would leave the jury to speculate that.
I'm sorry to interrupt you. Go ahead. But doesn't he have the same interest, the same penal interest, or arguably the same penal interest, because of the pending appeal? So it's not just, maybe it's Section 9 where there are pending appeals. Your argument, I think, has more weight if there were no pending appeal. I say, okay, I see the distinction. But given the pending appeal, doesn't he have the same interest as if he were in a criminal environment or in a prison environment?
Well, he had actually joined treatment in this case shortly before the trial in a portion of the program where he didn't have to admit to his crimes or to discuss his crimes.
Right, so that's distinguishable, that treatment program.
But it's a program that he had not entered in. This trial was in March of 2019. He didn't enter into that program until I believe July of 2009. January of 2019. But overall, this is a decision that the legislature has made as a matter of policy, that the treatment at the treatment center for civilly committed men is not confidential. So it's not a question of waiving confidentiality, because he doesn't have a statutory right to it.
Right.
He doesn't have a constitutional right.
The SJC has said that's fine, but we're going to limit how the evidence goes in. And that's what this case is about, is does that limitation apply?
And again, I think because it's of the nature of his commitment, that it does not apply. And that, again, the prejudice to the Commonwealth is manifest, where a jury could again say, well, this is somebody who's done with their sentence, yet the state's still holding him, and they could speculate that he's not being offered treatment. They don't know, they're not going to know why he hasn't been offered treatment. So when that's the whole nature.
Well, the speculation could go both ways. It's not, the speculation could be, yes, he's in a treatment center and he's not being treated because he doesn't want to be, or he's not being treated because there's no treatment available. But Hunt seems to indicate you can get in that he has not been treated, but not provide the explanation.
Right, but I mean, that's still prejudicial, because the jury would just sit there and all that they would know was that he has not been treated. They won't know the reason for it. And when that's the reason for his commitment, that's the prejudice to the Commonwealth, is that the jury can speculate that, he's not being offered it. And so that's where the prejudice is to the Commonwealth.
Well, if it's prejudice to the Commonwealth, it's prejudice that the SJC is blessed. I'll quote again from their decision. Where sex offender treatment is conditioned on a waiver of confidentiality, refusal of treatment alone is insufficient to support an inference that the prisoner does not want to be treated. That's the rule they're trying to set.
And I think
I just want to pair that with part of the opening so that you get an opportunity to respond. This statement was made in various ways. Such and such a witness will talk to you about some of the details of the crimes and Mr. Murphy's outright refusal to participate in treatment because of his ongoing appeals and what he claims is lack of confidentiality. Isn't that an argument based exactly on the inference the SJC says we can't draw?
Well, at that point, the Mr. Murphy's attorney and Mr. Murphy had agreed for the evidence to go into that point. So in a way, Mr. Murphy benefits from that because he gets to put before the jury his challenging his guilt of the underlying crimes without having to testify. So by the time the Commonwealth opened in that case, Mr. Murphy had already agreed to proceed under those parameters that, okay, we'll say he chose not to do the treatment, but we want the jury to know that it's because he's challenging his underlying crimes and that he has appeals pending that challenge the validity of his convictions.
So you're saying you opened the door to all of it?
I think once he agreed to do that before the judge had decided that the door was open, and once that agreement was made, the Commonwealth proceeded in the manner that Mr. Murphy agreed to agreed to proceed in trial.
So there may very well have been some strategy to that.
Yes, and I think there was a very much strategy to that because, again, he, without having to testify and say he didn't commit his crimes, now he has the evidence that he is challenging his convictions. He says he's not guilty. He told that to the qualified examiners. He told that to his own witnesses. So that evidence it was a strategic decision for Mr. Murphy that benefited Mr. Murphy, and to be able to get that evidence out without having to take the stand. And I see my time's up, so unless there's specific questions on the other issue, I will the Commonwealth will rest on its brief.
Any other questions, panel? No. All right. Thank you both for your arguments, and we wish you both a healthy and safe balance of the year.
Thank you. You too, Your Honor.
The case is now being recorded.
Good morning, everyone, and welcome to the March 9th, 2021 session of the Massachusetts Appeals Court. My name is Mary Thomas Sullivan, and your panel today will consist of me, Justice Kenneth Desmond, and Justice Savita Singh. Our virtual oral argument will follow all the same rules as an in-person oral argument. Each side will have 15 minutes in which to argue, and there is no rebuttal, and counsel are encouraged to proceed to the heart of their argument, and you can assume that we are familiar with your briefs and portions of the record. To those of you who may be watching, if we have any technical issues, we will do our best to resolve them quickly. If we have to go offline in order to do it, our screen may come down. Rest assured that we will be back and we will resume the argument. And finally, to the extent that I or anyone else looks from side to side, it's no disrespect and it's not inattention. We simply have our case materials to one side of the Zoom camera or another. And we are looking at the materials we have in order to be prepared for oral argument. The next case is 20P0840, James Stevens versus the Commonwealth. Attorney Simons, you may proceed.
Thank you, Your Honor. I know that the panel has reviewed the filings and the underlying factual submissions with the appendix, but I have to start with this. I think the most important piece from Mr. Stevens' point of view is that unequivocally, he was innocent of possession with intent to distribute narcotics, and he served over 6 years in prison for that charge. The jury in this case found by clear and convincing evidence that he was factually innocent of that charge. And now the government, the Commonwealth, wants to claim that he should not be entitled to compensation for that erroneous conviction. There's no ambiguity that he was, in fact, innocent of that charge. So the heart of the case.
So hold on, I'm going to interrupt you for 1 second. So you say innocent versus not guilty, and I assume that's on purpose by design, right?
Well, yeah, I do. And actually, that's something that we were required to prove in the trial court, that he actually is factually innocent rather than simply not guilty as in a criminal case. So I do say that by design. And our burden in the trial court was by clear and convincing evidence, which is I would argue, a fairly high standard. And so that was question one for the jury. Was Mr. Stevens factually innocent of this possession with intent to distribute narcotics charge? And they found yes. And there was no jury questions about that charge. But where the jury was confused, and where I'm arguing that the case should be overturned based on erroneous convictions. Although there was no objection in the trial court, this court, I assert, would still have the ability to review, and the review would be based on whether the erroneous instructions created a substantial likelihood of a miscarriage of justice. And I would argue both that
if I may stop you there for a moment, this is a civil case, and I think you mean substantial risk of a miscarriage of justice, because this isn't a first-degree murder case. What is your authority for the proposition that in a civil suit for damages, the substantial risk standard applies?
You know, I don't have anything in front of me, and I don't want to just, I don't want to spend the time looking through my notes for an answer I might not be able to find. I apologize, I don't have it. I'm happy to submit something post-argument.
That's okay. That's okay. I was just curious, and I just wanted to give you an opportunity to answer that question, because this challenge to the jury instruction that you're raising now on appeal was not raised at trial, correct?
That's right.
There was agreement to the instruction. So the normal civil rule would be that any objection to the instruction was waived. And I hear you to be making kind of a hybrid argument for a hybrid case.
That's where I'm stuck. And I don't know that there's precedent on this. I mean, it's a case I sort of look to, as you'd see later in my brief, I look to certain criminal authorities, because it is the underlying cases were criminal cases. Now we bring the civil suit and we're relating back. And some of my arguments have to do with proof of whether or not the government could tie the two charges together. So I'm not sure, but I'm happy to supplement.
Okay. Go ahead. Well, that's all right. Just go ahead.
If the court agrees with me that there is a review to be had, as I spelled out in the argument in my brief, you know, one of the instructions, I apologize, one of the instructions that the judge gave was, I would say, not only ambiguous, but also caused the jury to actually come and question what the relationship needs to be to arise out of or be reasonably related to facts that support the two charges. So if Mr. Stevens was found to be factually innocent of the possession with intent to distribute charge, I would argue that there's got to be something more than just a connection, something that, otherwise there's a connection between every time somebody's charged. The connection is that it's the same defendant or the same court or the same search warrant. And the judge actually said in this case that having been the result of the same search warrant doesn't mean that the charges are reasonably related by themselves. But I would suggest
So
that.
can I ask you, what's your understanding of what's the purpose of this particular requirement? To help us understand, maybe that would help us put into context what connection should mean.
I think that the intent was to prevent people from using this erroneous conviction statute to get money when there's a technicality and when they truly are guilty of basically the crime that they got off of. And so I thought of this too, and I try to think of examples. I racked my brain, and I just thought of one this morning, and I hope that this makes sense. I thought of if a person was charged with both rape and indecent assault and battery, and they were convicted, and then the conviction was overturned, and everything else was satisfactory, meaning the burden that they have to prove is satisfying, except that the rape charge was overturned and they were suing on a wrongful conviction, and yet the indecent charge stayed. I would argue that the facts reasonably would be connected to both the indecent and the rape, even though they may not have been convicted of the rape, rather than the rape was overturned. So that's a case where clearly the facts would be the same, or at least reasonably connected to. But I think there's got to be something like that. There's got to be something where there's.
In that case, so the defendant would have suffered a consequence in that the rape conviction presumably would have led to a more serious sentence. So he would have had some sort of he would have had prejudice resulting from that, to which he could seek compensation.
That's correct. And I would still think that that may be unfair, but unfair isn't what the law, suggests. And I think there's got to be a reason. And the only reason I can think of is that again, that would sort of be the person's still guilty of the conduct. It's reasonably related to.
Okay, just in a different name.
Just in a different name, but they still committed the acts that led to the crime that was overturned. And I think otherwise, if there's no more than just a connection, like I said, every charge, it's hard to envision any sort of time when a person could be charged with more than one crime and one conviction stays and one gets overturned by virtue of them being charged. It's the same person, it's the same court, it's the same, police sweep, so to speak. And clearly the legislature intended for people in situations where there's multiple crimes to still be able to get compensation, or else they wouldn't have put that clause in there in the first place. So
well, I mean, the example you cited was along the lines of a lesser included. But let's say there's, 3 distinct different crimes in a criminal episode. Would you say then that they're not connected because they're wholly distinct crimes?
Well, I think there's got to be some sort of a causal connection between the facts underlying each crime to each other. So I think if the facts supporting one crime are causal or causal to one and also causal to the other, I think then it has to be the same set of facts. I mean, if Mr. Stevens was charged with, let's say, child pornography, something that the police didn't expect to find, but that was in his house on the computer, it's hard to conceive of how the government could argue that that's reasonably related, although I'm sure that, they probably would try to find a way and say, well, it's the same apartment, and somehow Mr. Stevens was trying to change his identity. And you could say that about almost any crime, right? Almost any criminal would try to change their identity. So if you have this false license charge, it's always related to every other charge because you're trying to evade authorities by using a false identification.
Is it possible that that's what the legislature meant, though?
I think if the legislature meant that, we have to presume that they would have said that and that it would have been intentionally included into statute.
Well, the statute says reasonably connected to the facts. So the police come in, he's charged with possession of narcotics on September 7th. The jury finds him factually innocent of possession of narcotics on September 7th. But there's also a lot of testimony as to how the finances, his finances and his girlfriend's finances are very closely intertwined. And when the police arrive, he gives them the false name. It's not just that they find the false license. He gives them the false name. So could the jury have concluded that even though he may have been factually innocent of possessing that cocaine, it may have belonged to her or someone else in the apartment, that he was attempting to shield them and himself by giving a false name, and therefore it's the charge is reasonably connected to the facts on September 7th.
I think in another circumstance that could be true. I think given the record before the court, though, the jury was clearly having trouble with that distinction of what made something reasonably connected to or arising out of.
Well, the jury was aware of, or were they aware of what precipitated the search? That is, the confidential buys that preceded the search. And so that drug dealers, like you say, and many other offenders, try to distance themselves from their participation in the drug deal. And so they knew through strong evidence, I'd argue, or I'd suggest, that he was participating in drug dealing. They had confidential informants involved in buys and what have you. And to Judge Sullivan's point, he carries this distancing himself throughout. When they get there, they actually think he's Taylor, or whatever the other name was, I forget exactly. And that's carried all the way through to the police station until actual fingerprinting. And there's evidence that that's what drug dealers do. So why is that not reasonable connection?
Well, I think if it was clearly a reasonable connection, the jury could have just found that without having to question the judge's instructions. And I think that's why this is problematic. And that's why I'm suggesting that there is a real risk of injustice here, because the jury was confused. This jury, not just hypothetically a jury. I mean, this jury was confused. And what I'm suggesting too is that I'm hoping this court will help to clarify the standard, because one of the things the judge said on page 13 of my brief with regard to the jury instruction was that to find that the false application charge arises out of the narcotics charge, you would have to find that the facts supporting the false application offense originate from, grow out of, flow from, or have a connection with the narcotics charge. So the problematic part, I think, for Mr. Stevens is having a connection. I mean, again, it goes back to a connection can be very broad. I mean, Attorney Hornstein and I have a connection. We're both attorneys. We're both on the same case. But, you know, and in a lot of other respects, you know, we're on a different side of the case. We have different arguments. We have different, you know, types of practices. So, you know, same with all of us in the room. We're all attorneys, but that doesn't mean that we're all doing the same thing day to day. I mean, it would be very tenuous to say that we have the same lives because we're all attorneys at heart. So, you know, I think there's got to be some clarification. And again, the demonstration in this case, why there's a risk of injustice is that the jury was confused. They came back, and I suggest that the instructions just weren't they weren't sufficient. So
would it be possible for this jury to have found that he didn't possess the drugs that were found in the apartment that day, but that he had been part of an operation with the other occupant of the apartment, and that his license status was part of an attempt to conceal their dealings?
Is the question, just to clarify, do you mean whether or not Mr. Stevens and his girlfriend at the time would have been involved in the drug trade together, and that somehow he was trying to evade capture with the ID?
Yeah, and to shield both their identities.
I think that requires a little bit of speculation. I mean, I suppose they could have, but I don't know that that changes the argument that if Mr. Stevens was factually innocent, I mean, the only thing we're arguing is that he was factually innocent of this one charge. I don't believe there was any testimony that Mr. Stevens had never dealt drugs. And in fact, I think there was evidence that Mr. Stevens certainly did have a past, and a jury could find that they were controlled buys. I just think with regard to, if you're limiting to the case before this court, is there any way that these charges, is there any way the facts could have supported both a charge that he didn't commit? I mean, he was factually innocent. If you go by what the jury found, how could that possibly have been reasonably related to a charge that he did do? You know, he did commit, he did agree to, and he did plead guilty to. So I just don't think it's possible, and I think that goes sort of to my legal inconsistency argument, although I think that the jury charge argument is my stronger of the two. I see that my time is about to run, so unless there's any other questions, I would rest on the brief and the argument that I made. Thank you.
Any other questions? No. AAG Hornstein.
Good morning, Your Honors, and may it please the court. My name is Adam Hornstein. I'm an Assistant Attorney General, and I'm here today on behalf of the Commonwealth to urge you to affirm the judgment that was entered after a jury verdict, not only because the two arguments plaintiff advances on appeal are waived, but also because the trial judge's jury instructions and the jury's ultimate verdict were consistent with the language and structure of Chapter 258D. I want to begin by attempting to answer Justice Sullivan's question that was posed to Mr. Simons earlier about whether there is any basis in Massachusetts law to say that the waiver rule embodied by Civil Rule 51B does not apply in these circumstances, which is to say that can this court import the rule from criminal cases about a substantial risk of a miscarriage of justice into the civil arena? And the answer flatly is no. The waiver rule applies, it is ironclad, and there is no basis, there are no cases that would support Mr. Stevens' interpretation of the rule or attempt to modify the rule that is embodied in Civil Rule 51B. Now, plaintiff cites to several cases, Torres among them, but these are criminal cases applying a different set of rules.
What about RB petitioner, where substantial risk analysis is extended to an STP? Clearly, this Stevens is out of jail at this point, but he did spend 6 years in jail. So is there an argument to be made that because of the liberty interest that was previously at stake, which is the basis of the extension of the rule in RB, is the future liberty interest actually of the petitioner there? But because of is there any argument that because what was at stake in here was wrongful incarceration, that we should apply a substantial risk analysis to the subsequent civil case?
Yes, Your Honor. And I think the operative words in your question are liberty interest. Is Mr. Stevens' liberty interest at stake here? The answer is, again, indisputably no. There's no dispute that Mr. Stevens spent 6 years in jail as a result of this criminal case. No dispute, but that criminal case is now over. This is a civil case. The only thing at stake, the only thing that ever has been at stake in this case is money damages. This is a civil case. The civil rules of procedure apply. This is not an SDP case, for example. And again, the liberty interest is not at stake. That's what distinguishes it from both the criminal context and the SDP context, where, again, people are going to jail. That chapter is done. We wipe the slate clean. This is a civil case, Your Honor. And I think even if this argument were properly presented to this court, Your Honors, plaintiff still, his argument for a different interpretation for the term arising out of is not a basis for reversing the judgment below. Not only because Mr. Simons himself urged the trial court to adopt this very definition of arising out of. Again, this is in the transcript, day 5, page 16. Mr. Stevens' counsel urged the court in response to the jury's question, to say that arising out of means originating from, having its origin in, growing out of, or flowing from. And he cites 2 insurance cases from the state of Florida. That's essentially almost verbatim the instruction that the judge gave here. And it is perfectly consistent. I think this is what Judge Singh, or Justice Singh, was asking about previously. What is the purpose of this requirement? We know from the SJC's decision in Irwin that the purpose of Chapter 258D as a whole was to effect a limited abrogation of the Commonwealth's sovereign immunity, such that plaintiffs who found themselves alleging that they were erroneously incarcerated could find civil redress. Section 1C of that statute sets forth the elements that a claimant must ultimately prove by clear and convincing evidence. Among them, the requirement in Section 1C6 that we're discussing today, which is the requirement that plaintiff prove that he did not commit any other felony arising out of or reasonably connected to the facts supporting the indictment. That language and other language in the statute, I would point the court to Section 1C5, Section 2, and Section 5 of the statute. All have language in them that make it clear that the only claimants who are entitled to recover under this statute are those that come to the court with absolutely clean hands. If you've committed another crime, that is, again, to use the language of the statute, arises out of or is reasonably connected to the facts supporting the indictment, that's 1C6, you are not entitled to recover. Again, 1C5 deals with a slightly different concept, the idea of sole incarceration. Section 2 also picks up on that concept. Section 5 also picks up on that concept. The overall structure here that we're dealing with is the idea that just because you're innocent of one crime does not mean that you are innocent of all crimes. And because of that, it does not mean that you are able to recover unless you prove all of these things. The jury here, unfortunately for plaintiff, concluded that he did not discharge his burden of proof under Chapter 258D, and as a result, he is not entitled to damages here. Now, that is in sum and substance the jury instructions argument, but let me add one more layer here. Again, we know from longstanding law that instructions will be deemed appropriate, again, if the argument isn't waived, unless the jury instructions are both erroneous and prejudicial. There are two connector terms in the language we're discussing, from section 1C6. There's the arising out of terminology that Mr. Stevens ascribes error to, but also there's the reasonably connected to language that Mr. Simons and Mr. Stevens do not ascribe any error to. Now, the jury verdict form, you can find this in the appendix at page 72, asks, again, tracking the language from the statute, one question covering both connector terms. And the definition that the court gave for reasonably connected is actually far broader than the instruction that the court gave on arising out of, which is to say that if we were creating a Venn diagram for the jury instructions here, the reasonable connection is rather large. The arising out of is smaller there. So again, I will ask.
Yes, but on page 14 of the appellant's brief, he does take some issue with the reasonably connected language. Does he not?
Respectfully, I would submit that Mr. Simons only submits proposed different language on the arising out of connector. The challenge is not, as I read it, and I confess I may be wrong, Your Honor, to the reasonable
I had originally read it as you did as well, but when I went back to it, I realized that on page 14, there is some issue being taken with the reasonably connected language as well. Not as much. But
if that is the case, then, Your Honor, your read of Mr. Stevens' brief may well be better than mine. And if that's the case, I will certainly defer to the court's reading of plaintiff's argument. But in any event,
there isn't a citation to authority, but there is a sentence that says the standard set forth in the second test also opens up a wide range of possible relationships that do not align with the intent of the statute.
In any event, the argument is still not properly presented because Mr. Stevens didn't object to it below. And again, the Rule 51B rule here is absolute. It is ironclad. Object, or you can't make the argument on appeal. And I think that is a nice segue, Your Honors, to the second argument that Mr. Stevens advances here, which is on the alleged jury verdict inconsistency, which is the idea that the jury's verdict itself is inconsistent with Chapter 258D, its language, and its purpose. Again, there's a huge waiver problem here, Your Honors. The rule, and this springs from Civil Rule 49B, which contemplates what courts should do when an allegedly inconsistent verdict is raised, and that is you have to object before the jury is discharged, otherwise you waive the argument. And there's a reason for this.
Yes, Stevens concedes factual inconsistencies. Does the same waiver rule apply? Well, first of all, does the doctrine of legal inconsistency apply in a civil context? And if it does the same waiver rule apply?
Two excellent questions, Your Honor. The cases that plaintiff cites to drive a wedge between factual and legal inconsistency both arise in the criminal context. The cases he cites, I believe, are the Walker decision and the Elliffey, ELLIFFE decision, both of which arise in the criminal context. And again, Civil Rule 49B would not apply under those circumstances. So I seriously doubt that this distinction the distinction that plaintiff offers, again, applies in a civil case. But also in those two cases, there was no issue of a failure to object on the part of the criminal defendant there. In other words, the defendant properly raised an objection. There's no dispute here that, again, Mr. Stevens did not object at the time the verdict was rendered, but before the jury was discharged. In cases like Uloth, Adams, Holder, Low Supply, and Kuwaiti Danish, all cases cited in my brief, seem to suggest that for a very long time in Massachusetts procedure, the rule is in civil cases, again, the argument is waived unless you object. But again, even if this argument were properly presented, there is nothing that is inconsistent between the jury's verdict and the structure of the statute. Again, this is not a sufficiency of the evidence challenge. This is an argument that the jury's verdict was somehow in tension with the language of Chapter 258D. But as Justice Desmond discussed in his questions to plaintiff, there was ample evidence received by the jury of prior pattern and practice, of the drug sale paraphernalia, of the reason why Mr. Stevens had a bogus driver's license made out in another person's name, how after he was arrested, he maintained his pseudonym. Why? Again, because he had a record, because he was attempting to elude the police's investigation. When the police conducted their raid of the Prospect Street address where he was living, they thought they were going to arrest a man named John Taylor. Plaintiff's ruse worked. And again, this is precisely why the legislature included the language in 1C6 about related crimes. This case—
Do you view that as a factual inconsistency, though? An argument regarding factual inconsistency in the verdict, i.e. how can he be not guilty, how can he be innocent of the drug trafficking, the drug distribution charge, and at the same time be considered part of a drug distribution network? Is that a factual inconsistency or a legal inconsistency?
Well, I think it is not inconsistent on either score, Your Honor, is what I'm trying to say. And I think let's be hyper precise.
But how would you best characterize the argument?
I would best characterize the argument that Mr. Simons has advanced as being a factual inconsistency argument. But let's be precise about the potential alleged legal inconsistency by being hyper precise about the language. It is not whether or not plaintiff has to prove by clear and convincing evidence that he didn't commit any other felony arising out of or reasonably connected to a crime. That's not the language. It's arising out of or reasonably connected to the facts supporting the indictment. And here, all of those facts about the drug dealing, about the drug selling paraphernalia, about the cash, about the evasion of the police, et cetera, all go to the concept of the facts supporting that in the indictment. Indeed, the prosecutor here thought that this chain of events was so related that he was indicted on both charges in the same case. This isn't some pie in the sky theory. This is literally, same indictment, same case. So as a matter of law, and I think this is what Justice Sullivan, you are asking about, there is nothing that is inconsistent between Chapter 258D, its language, its structure, its purpose, and with what happened here, i.e. the jury's verdict. And so again, even if this argument were properly presented, respectfully, plaintiff doesn't actually identify any legal flaw here that would necessitate reversal. And let's keep in mind, of course, that we only upset verdicts for inconsistency in truly extraordinary cases. We have to presume that the jury did its job and that it harmonized the facts appropriately. Again, I see that my time is rapidly dwindling. And unless there are any further questions, I would certainly thank Mr. Simons for saying that we have a reasonable connection here. I share that as well. And I would thank the court for its time. If there is nothing further from the court, I would be happy to submit on the briefs. Thank you very much.
Any further questions from the panel? All right, well, thank you both for excellent arguments, and we wish you a healthy and happy and safe balance of 2021.
Thank you, you too.
The case is now being recorded.
Good morning, everyone. Welcome to the March 9, 2021 sitting of the Massachusetts Appeals Court. We are here to hear our final case for the day. My name is Mary Thomas Sullivan, and your panel today will consist of me, Justice Kenneth Desmond, and Justice Sabita Singh. All of the usual rules will apply. There will be 15 minutes per side, no rebuttal. If we have any technical issues, for those of you who may be watching this, we will do our best to correct them quickly. If we have to go offline, our screen may come down momentarily, our live feed may come down momentarily, but rest assured we will do our best to get back on. And finally, if you see me or anyone look from side to side during the course of the argument, please, we mean no disrespect whatsoever. And we are not inattentive. It's simply that the materials that we have used to prepare to hear the case today are to one side of the camera or another, and we just have to look to one side or another to see them. So the case we have next is 20P0514, Department of Children and Families versus Father and others. This is an impounded case, and all the parties will be using pseudonyms. Attorney Chenevert.
Thank you, Your Honors. May it please the court, my name is Dana Chenevert, and I represent the appellant father. The case involves an older child with whom father had a significant relationship, and also a younger child who I will refer to as child one, who is father's biological child. And if this court's paramount concern is the children's best interests, then this case must be remanded for further proceedings on the permanency plan, particularly the denial of visitation, as the lower court's approval of this plan, of this guardianship, which leaves visitation to the discretion of the guardians, was the approval of which was an abuse of discretion. And it was based on a clearly erroneous finding that father shared no bond with either child or with child one. When there's testimony, the record does support that, and the finding I'm talking about that's clearly erroneous is conclusion of law 42. That's on record appendix at page 119. And then there's also testimony by the DCF social worker at the transcript at page 491, which are supportive of the fact that father did share a bond with his son. You know, in the judge's words in that conclusion, there's no evidence of a bond. However, when we look to evidence in the record about the visits with father, the record provides ample support for the contention or for the visits or for the bond that forms through the visits. Father was, DCF points out in their brief that father missed a period of time with the visits. We'll see more formal visits with DCF, but as argued in my brief, Your Honors, father was seeing the children even through informal visits as facilitated by mother. And there's pictures at exhibits 2, 3, 4, or 3, 4, and 5 that depict the time that father spent with these children. Also, an error on the lower court's part was a failure to make a reasonable inference that just because there's no biological link between father and child two, that visitation should not even be considered. And we would, our position is that father was this child's de facto parent, and that was not an argument that father needed to have asserted proactively at trial, because under the case, Humans versus Ramos, the case that the judge in that case, sua sponte, took up the issue of de facto parent and allowed that de facto parent, that adult with whom that child had a significant relationship, to have visitation rights with that child to whom she was not biologically linked. So father posits that that issue was not waived. That issue did not, it was not waived. It did not have to be raised by him at the time of trial, that the court could have looked to evidence and made that finding herself, and that it was an error that she didn't. As she is supposed to, as trial judges are supposed to consider all factors that are relevant to a child's best interest in making a custody or visitation order. And that did not happen in this case. And such an order on balance is necessary. A visitation order is necessary to further the children's best interest, because the record supports that the guardians are not going to ever facilitate visits. The testimony of the guardian himself at the transcript, page 491, is that the child needed to be out of high school or in college in order to be able to establish some sort of relationship with the father.
But is that tantamount to having no visitation?
Well, yes, it is, because the children were very young at the time, at the conclusion of trial, 2.5 and 1.5, and essentially what this court's order purports to do in leaving it to the discretion of guardians who clearly, father, they were not a fan of father, is depriving these young brown children of a relationship with the only father that they've ever known, either one of them have ever known. So yes, to say that, these 1-year-old, 1.5-year-old, and 2.5-year-old are not allowed to see their father until they're 18, that is their whole entire life. There would be no meaningful relationship there. Father would be a stranger to these children.
So that all flows from the finding of no bond.
That's right. I believe that is our argument. Yes.
Can you capture for me the evidence from which the bond could be found?
Yes. So if we look at the visits, Your Honor, at father's brief on page 41, where father resumed his formal visitation with child 1 in March 12th, 2019. During those, the social worker himself testified that the child was, quote, in tune to the bond that there was between parent and son, parent and child. That's at transcript 491. In describing those visits that exhibit volume 161 and 162, it describes very intimate interactions between the child 1 and father. They played together. The child shared his fruit snacks with father, which, we know how possessive toddlers can be with their fruit snacks. The child pointed out the window. Father picked up on those cues and took him over to the window so that they could look out together. Father, he performed caretaking responsibilities, such as changing his diapers and teaching him and asking him about his favorite colors. During the informal visits, or actually while father was with mother at the time that both children were born, and father testified, offered unrefuted testimony, and actually, no, it's not unrefuted, it was supported by mother, that as to child 2, he preferred, even though there was no biological link between father and child 2, mother testified that he preferred father over her. That, he potty trained him. He taught him to speak and crawl, and he took care of him when he was sick.
Can I ask you this, that if the judge had found that there was a bond, could he still have made no provision for visitation?
Well, yes, we know that the judges have wide discretion in determining, whether visitation is warranted in any particular situation. But the argument is that the failure to consider the evidence of in finding that there was no evidence. That's a clearly erroneous finding when the record clearly shows that there was evidence of a bond. And for the court not to consider that and enter the order, leaving visits to the discretion of the guardians who clearly were not in favor of visits, that does not further the child's best interest, and it was an abuse of discretion.
That being said, there is a distinct difference, I think you would agree, between not ordering the visitation and prohibiting visitation.
I would agree with that nuanced position, Justice Desmond. But I would say constructively, there is, there's a presumption that guardians and foster parents are going to act in the children's best interest, including in instances where they're making determinations about visitation. However, we would argue that it's a rebuttable presumption, rebuttable by evidence that shows that that guardian might not act in this child's or the children's best interest. And I would say that that evidence exists through the foster parents' testimony outright. This visit's not going to happen until this child is of age of majority. And at that point, the child would be able to make the decision on his own. He would be an adult. But while the child...
You agree that domestic violence permeated this case, and there's record evidence that some of that occurred in the children's presence?
I would agree that there was yes, domestic violence in the relationship. However, and I would say though that yes, that the domestic violence that was perpetrated in the home was at least one incident occurred in front of the child, in front of both children, and that's the incident that occurred in November 2016, where actually no, that was the incident that occurred. Well, actually, there was incidents of domestic violence that were testified to that occurred while the family was a unit. And this happened when the children were very young, and it was testified to by the paternal grandmother that the domestic violence was perpetrated by mother against father, where mother threw a glass jar of barbecue sauce against the room with such force that it shattered when it hit the wall. There were other incidents of domestic, and it was father who was protecting the child from the barbecue sauce that was everywhere. The domestic violence incident that occurred in the South Shore Plaza parking lot, neither child was there. The incident that occurred when mother showed up at father's work in November 2016, jumped into his car and bit him on the face. The child was not present for that incident. So yes, there were many incidents of domestic violence that were testified to by mother and by father, primarily instigated by mother, the ones that were corroborated by other evidence. But the majority of these incidents did occur outside the presence of these children, which brings into, which is a great segue to how the trial judge's findings don't address the impact of the domestic violence on the children. And under Vaughn, under RH versus BK, and then as affirmed by custody of Vaughn, it's reversible error for the judge not to make such findings. And that is the case here, where DCF's case against father did have to do with domestic violence. Its primary case was against father and domestic violence in the home, but there are no findings to that effect, to how those incidents of domestic violence impacted the children. Along those lines as well, the trial judge's findings regarding mother's mental illness and how that factored in the cross-section of mother's mental health and the domestic violence that occurred, there are no findings here about that whatsoever. And father posits that is in taking a look in reviewing the case of father's unfitness, father posits that determination requires close scrutiny. And that is because you know, and mind you, father is not blaming mother for her mental illness. He's not blaming her being sick, and he's not minimizing his role in staying, right? He's not saying he perpetrated violence or, you know, he did not act appropriately at all times, but he did not at any point slam mother to the floor as she had alleged in her 209A, her report to get the 209A in November 2016. That evidence that the court took into consideration, crediting mother's testimony in direct contradiction to police reports, for example, that was an error. But as far as the fitness goes, father would ask this court to take a really close look at the absence of those findings as they pertain to mother's mental illness and her role in that.
But perhaps the judge, I mean, wasn't it because of the posture of the case? At the time the findings were made, the mother had already had an agreement. I mean, this wasn't something that the judge needed to focus on.
Well, father posits that it is when looking at his unfitness and looking at all the evidence, the judge is required to consider all the evidence and take everything into account when making an even-handed assessment of the evidence, especially when it comes to making a determination about parental unfitness. And the error in this case is that did not happen because the findings related to mother's mental illness and how that manifested in angry outbursts and things like that, they were not taken in consideration. They weren't considered in the balance.
All right. Well,
so I see that my time.
Yes, thank you. Did the panel have any other questions? All right, I believe it's Attorney Gagel.
Thank you, Your Honor. May it please the court, Ezra Gagel for the Department of Children and Families. The evidentiary record in this case conclusively supports the trial judge's detailed findings that father is unfit to parent the child, and that it is in the child's best interest for to terminate father's parental rights so that maternal grandparents can serve as his guardians, the same role they are serving in for his half-brother. Today, I would like to briefly discuss what the record establishes regarding father's erratic, abusive behavior, what the record establishes regarding maternal grandparents' loving, supportive behavior, and also address father's arguments, which are largely trial-level arguments attacking the trial judge's weighing and credibility determinations. But even following father's arguments, father does not have sufficient basis to overturn the trial judge's detailed findings. So
could I ask you to turn first to the visitation issue? Given the nature of the relationship between the father and the maternal grandparents?
And maternal grandparents, or yes. And so as this court noted in its questioning, visitation is not required, and visitation largely serves as a bridge between when a child has a deep bond with a parent, and then is moving to a new caregiver, to a new guardian, to a new adoptive parent. And here there is no deep bond between child and father. Father could have seen child, could have had upwards of 50, more than that, supervised visits in the 2 years before trial. Father had 7 such visits. Father hardly saw the child. The trial judge found that father was never alone with the child in the 2 years leading up to trial. And as Justice Desmond pointed out, the trial judge did not prohibit visitations between the child and father, but left it in the discretion of maternal grandparents to act in his best interest, which is a position that this court and the SJC have routinely adopted and routinely endorsed, such as an adoption of Ilona.
Except in this case, there was explicit testimony from which you could conclude that those visits were not going to happen. So isn't that tantamount to the same thing?
No, it's not tantamount to the same thing, because this is a point in time of maternal grandfather's position that it is currently not in the child's best interest, and his view that It is in the child's best interest for the child to become more mature, to understand the relationship between himself and the father. And father has ample opportunity over the next many years to prove himself to maternal grandparents, such that maternal grandparents feel comfortable trusting father with the child. But here there's ample evidence in the record, and this is kind of the nub of the trial judge's conclusions here, where father has this pattern of erratic, abusive behavior, and the trial judge did not feel comfortable trusting father that he would not continue this violence. And as my sister counsel pointed out, there is evidence in the record that father engaged in this behavior in front of the children. There's an episode in November of 2016 when he forces the half brother and mother out of his apartment on a cold December night with no way to transport themselves to safety. There's another incident when he attacks mother when mother is asking him to keep quiet so that the half brother can nap in the next room. And there's an incident when they have a brief moment of reunification when father's violating a 209A order to be near mother 2 years before trial, when he pushes mother with sufficient force that she falls into the half brother, and this is in the presence of the child. So all of those reasons show that that father has this history of abuse, there's a history of violence, and support maternal grandfather's testimony that he doesn't have sufficient trust that father would be in the child's best interest to have these visits with father currently, until father is able to prove himself differently, or until the child is able to become mature enough to understand the ramifications. And so turning from father's behavior, which not only included this abusive, erratic behavior, failure to see the child, but also defiance of the department. He adopted that word at trial, that he chose to defy the department, and not engage in supervised visitations, not engage in classes, so that he could understand the distinctly grievous kind of harm that he was causing the children. And then you look at if this court examines where the child is with his half brother, he's in a loving, supportive home right now. The maternal grandparents take care of his every needs. They sign him up for early intervention, take him to daycare, take him, pack his lunches, do everything that a loving, supportive home will do for a child. And he is currently living there with his half brother in a very good situation for the child. And then just briefly examining where father does not dispute the evidence below. Father does not dispute that the domestic violence was endemic in the relationship. He does not dispute that he did not see the child. He hardly saw the child for the 2 years leading up to trial. That he never saw the child when the child was with maternal grandparents. He doesn't dispute that he defied the department, and he doesn't dispute that he provided essentially no support to the child. So for that and the reasons in our brief, we ask that this court affirm the detailed, thoughtful opinion below. Thank you.
Thank you very much. Any further questions? All right. Attorney Campbell, are you next?
Yes, I am.
Okay.
Good afternoon. My name is Alan Campbell, and I represent the appellee mother in this case. I just have a couple of points that I'd like to touch on. First, following up on the visitation question. This isn't a case where the court found that visits would be in the child's best interest and then left it to the discretion of people who likely wouldn't give visits. The court found that visits weren't in the child's best interest at this time and said, given this circumstance, I'll leave it to the guardians to determine if at some point in the future visits are in the child's best interest. That's perfectly reasonable, and that's what the court should have done in this case. So there's certainly no error. And the judge didn't actually find that there is no evidence of a bond. What the court found is much more nuanced. There's no evidence that readily points to a significant existing bond. So that's just a slight take on father's argument that the judge erred by saying there was no evidence. There was no evidence readily pointing to a significant existing bond. Father testified that he did all sorts of things with the child. Mother testified that that didn't happen. He did essentially nothing with the child. It's the court's job to weigh the evidence, determine credibility, and resolve disputes, and that's what the judge did in this case. Father is simply unhappy with the results. And then next to the argument that father is a de facto parent to the older child, or child 2, that argument fails for at least 4 reasons. First off, if you look at Record Appendix, page 76, father did not even appeal any orders regarding the older child. His appeal was specifically limited to his biological son. So any other issues relating to the other child simply aren't before this court. Second, they're waived as they weren't raised below. Third, and perhaps the most important, there's 2-prong test for being a de facto parent. You have to live with the child for at least 2 years, and you have to perform a significant share of the caretaking of the child. And by definition, the significant portion of the caretaking means a share at least as great as the biological parent. So more than 50% of the care. And he meets neither of those tests. The children were, I believe the older one was 17 months when they were removed. And there's no evidence that father had lived continuously with either of these children for 2 years. Then as to the other prong, father simply didn't care for the children. I think what he did was he played with them during the 7 visits he had. That's great. That doesn't mean he's a parent. He testified to income streams that aggregated to almost $100,000 a year, and yet provided no financial support for the children. I think all he did was play with one of the children during the 7 visits over a period of 2 years. And I think he may have taken the children to and from daycare a few times. That does not render an individual a de facto parent. And the argument that the court can just simply sua sponte declare somebody a de facto parent with that limited contact with the child is, that's just not the case. It's not the law and it's not supported by the facts. Just looking quickly. Oh, and then again, as to it's already been mentioned, but the lack of findings regarding mother, as Justice Singh pointed out, mother had stipulated to her unfitness at the beginning of trial and had agreed to a guardianship that would last at least 8 years. The issue of mother's fitness was simply not before the court. And yes, mother does have some issues that had she been fighting it would have needed to be addressed in the findings. But given the posture of this case, there was simply no reason to address them. They didn't go to the issue of father's fitness. And I know father's counsel has suggested that mother may have perpetrated some of the domestic violence. She very well may have. As the court found, it wasn't so important as to which one of them was perpetrating the violence, and it probably was both of them. But the court found is father was in a relationship where domestic violence was endemic, and he did nothing to take the children out of it or to resolve it. And as the cases are legion where a mother is the victim of domestic abuse and she still loses her children because she refuses to protect her children from the abuser. And that if you want to accept father's argument and say mother was responsible for everything, well, father still loses out because he didn't protect his children from mother in that situation. But again, it's not necessary for the court to have resolved that. And unless there are further questions, I'll rely on my brief for the remainder of the arguments.
Thank you. Attorney Don.
Good afternoon. May it please the court. My name is Andrew Don, and I'm appearing on behalf of the children. In the interest of not repeating the points raised by and argued by Attorney Gagel and Attorney Campbell, I just want to say, I think, 2 things. One is that I don't think it's correct, as Attorney Chenevert asserted, that the judge made no findings about domestic violence. If the court looks at conclusions of law number 6 and 9 on pages 106 to 107, the judge engages in an extensive analysis of the domestic violence and how that affects the children.
I think the argument was the effect on the children.
Yes, and so she engages in that throughout those two conclusions of law. The second thing is just to reinforce one thing that I think distinguishes this case from many other cases is that these children are in the home of their maternal grandparents where they've been for the majority of their life. So any discussion about the bond and things like that, they're secondary to the concern of what's in the best interest of the children. These children are in a loving home, as was laid out by Attorney Gagel, all the many things that the maternal grandparents have done and continue to do for these children. These children are stable in that home. With regard to the statement by the grandfather about the child maybe not seeing the father until they were 18 or in college, I think that was his assessment. I think you can properly say that that was his assessment at that moment in time about what he was judging to be in the best interest of the child. However, that certainly develops through time. There's no evidence that these grandparents had not or would not continue to act in the best interest of the child. And so while that assessment of the grandfather was at that time, there's every reason to think that they would act in the best interest of the child, as they had been doing through the whole of this case. So those are really the points that I wanted to cover. I don't know if anybody has any questions. Otherwise, I would rest on my brief. Thank you very much.
All right. Thank you all for a well-argued case. We'd also like to thank our clerk and clerk's office staff, our law clerks and interns, and our IT staff who has made our appearance, all of our appearances today possible. And we wish all counsel a healthy and happy balance of 2021. And with that, our proceedings for today are concluded. Thank you.
Thank you, Your Honor.